Hi, everyone. My name is David Kolko. I'm the current chair of the American Immigration Lawyers Association, the Colorado chapter. And I want to welcome everybody here today. We have a wonderful presentation put on by the Rocky Mountain Immigrant Advocacy Network, as well as two of our AILA colleagues, Lisa York and Dave Simmons are here. Abby Johnson and Ashley Harrington are going to present in just 1 minute. We're asking people to we're asking everyone to come today because of this growing humanitarian crisis that's going on at the border. I'm sure everyone has been following the news about this, and it's really developing into a really serious problem. We expect over the coming months that the flow of children will continue to come into the United States, and regardless of what the federal government's response is going to be, it's already a huge problem. There's a lot of things that are going on right now with the immigration courts and the allocation of resources, but I wouldn't be surprised if in the next couple weeks we see some major announcements about how resources are going to be allocated for handling a lot of these unaccompanied children, including the possibility that a large number of the children could be coming through the Denver immigration court system. So keeping that in mind, we're really trying to create a task force or a large group of people that might be able to offer pro bono representation to these children. And ultimately, I think our goal is going to be to try and offer a lawyer to every one of these unaccompanied children that come through the Denver court. Rocky Mountain Immigration Advocacy Network, and Michaela's here somewhere. Michaela? Oh, I thought Michaela was here. She is here. Oh, she's outside. So, with the support of their organization, with AILA Colorado, the Colorado Bar Association, and every lawyer in Colorado, we're going to try to reach out to take one possible case. And we're creating a sign-up list today. We're going to send that around. There's actually two sign-up lists, one that I've created and then another one for Remain. If you can put your name on this list, that way we can create a listserv. There are three possible options. One would be to take a single case, or maybe two if the children start flowing into Colorado. Number two would be serving as a mentor for those of you that are really experienced in this field of law. Maybe you can mark down the box and check that you could be a mentor to other lawyers that are willing to provide pro bono services. And the last is to check a box if you want to be part of like a working group that we're going to try to form, so that if further issues develop, we have a list of people that we can reach out to and have a group of people that can help formulate how we might best respond. So I don't want to take up any more time because I know they've prepared a really great program. We're going to record it so that it will be available for us to distribute in the future. And with that, please help me in welcoming our panel.
Excellent. So I think what we're going to do first is just take a few minutes to have the panelists introduce themselves to you. Start with Ashley.
I'm Ashley Harrington. I'm a staff attorney in Remain's children's program, and I've primarily been working on the juvenile docket.
And I'm Abby Johnson. I'm also in the children's program at Remain. I help support the children's docket as well, and I work in a variety of different cases involving children who are non-citizens.
And I am Lisa York. I'm a solo practitioner in Denver, Colorado, and I am a newly elected director of the American Immigration Lawyers Board of Governors. And I am here because I think Remain is just an absolutely fantastic organization. I have handled volunteer cases for them. I serve as a mentor for their cases. And I think anything that we can do to kind of support Remain in their efforts to alleviate this situation, we got to support them.
I'm David Simmons. I'm an attorney in private practice, former chapter chair of the Colorado chapter of the American Immigration Lawyers Association, occasional adjunct professor at the University of Denver. I would echo Lisa's comments about Remain. I've been around long enough to remember when we didn't have an organization like this, and the difference that it's made has been tremendous. I'm here because I feel that this is the crisis of our age. This is the SS St. Louis of 2014, and we can either turn our backs on a refugee crisis and be judged by history, or we can do something about it. It's just that simple.
Yeah, and I just want to add to what both David Kolko and David Simmons said. I think we are uniquely situated as immigration lawyers and AILA members to really make a difference. And as David Simmons said, the world is watching, and we will be judged. And it is just an absolute, I've never been prouder to be an immigration lawyer. I have never been prouder to be a member of ALA Colorado, because the amazing, overwhelming volunteer
Please don't do that, because now I'll start.
It's just the outpouring of volunteerism, both locally, and ALA National has reported that they have never received the amount of a volunteer response to a need before. This is unprecedented. It's incredible. We really have the opportunity to make a difference, and I'm so happy that everyone is here. And in the words of Nelson Mandela, the true character of a society is revealed by how it treats its children. And with that, I'm going to turn it over to Abby and Ashley.
Thank you. All right. Thank you again for the amazing turnout today. We're going to be talking about sort of the nuts and bolts of representing these children in their immigration proceedings. There's a lot of information. You'll have the PowerPoint to go back to, and you'll have us here as ongoing mentors, and we don't always have the answers, but hopefully we'll be able to direct you where the answers are. So first I'm going to talk about the ORR process. And then I'll turn it over to Ashley to talk about the Denver Immigration Court's juvenile docket and what we're already doing at that docket and with those kids who are in proceedings. Ashley then will talk about the protections under the Trafficking Victims Protection Reauthorization Act, and how that interacts with this term UAC, right, unaccompanied child, alien child. Then we'll talk about the asylum procedures for UACs. I'll talk about special immigrant juvenile status, which is a complicated area of the law, but I'll try and give you an overview. I'll touch just a second on the U's and T's that could be available for some of these children. Then we'll talk about what's different about representing kids versus adults, because there are a number of differences. And then we'll turn it over to David Simmons to talk about out-of-state volunteer opportunities, and over to Lisa then at the end to talk about the national response and legislative advocacy. Okay, so the ORR process. It really developed first of how we currently treat unaccompanied minors that are coming over our borders. It really changed with the Homeland Security Act in 2002. So that's where we divided up. Department of Homeland Security is in charge of enforcement, and USCIS is in charge of benefits. And the care and custody, though, of kids should be placed not with ICE, but with ORR, so the Office of Refugee Resettlement. So that's under the Department of Health and Human Services. And that sort of was born out of the Flores-Reno settlement, where it talked about how juveniles should be treated differently, right? So they shouldn't be housed with adults. They should be given proper treatment while they're in the custody of Customs and Border Patrol, or while they're in the custody of the Office of Refugee Resettlement. What currently happens after a young person is apprehended at the border, if they are unaccompanied and they are a minor and not from Mexico, then they are processed through the Office of Refugee Resettlement, placed in a shelter where they're given medical care, they get to go to school, they also get legal screenings, and they get mental health treatment. And then as they're in this shelter, then the workers at these shelters are looking for a sponsor that could be a family member, a parent, a family friend to release them to. This is, as we discovered as we were going through our slides this morning, an old chart because it still designates ICE as the entity that does the care and custody, but this is the same sort of picture of the process, right? So it shows you how kids from Mexico are treated very differently. They're screened by Customs and Border Patrol under 3 areas. So if they've been a victim of human trafficking, if they have a credible fear of returning to their country of origin, or capacity issues, if they even have the capacity to answer CBP's questions. If they don't fall in any of those categories, then they're sent back home, back to Mexico. Other than Mexicans, OTMs as they call them in this chart. So these kids from Central America who are coming up are treated very differently. So they go through this ORR process, and this is just a picture of it, and I apologize, it's with the old term. We've already talked about this humanitarian crisis. I just wanted to highlight just the spike has overwhelmed this current system of how kids get processed, how kids get placed in ORR shelters, to where kids are being housed on Air Force bases, right? Lackland in Texas, 1,200 kids. Fort Sill in Oklahoma, 1,200, and a naval base in Ventura, California, 600. So if you can imagine those numbers, all of these protections and things, medical care, legal screening, getting Know Your Rights presentations, that whole system is stressed. And so what we can expect when kids arrive to us in Colorado is that they probably haven't gotten all of those services that they would normally get. They probably have no idea that they have eligibility for relief in the immigration courts. So that's also why we need your help. It's not just the numbers, but it's also that kids are probably going to be arriving without sort of that primer that they would normally get in a Know Your Rights presentation on the border. So kids are coming to Colorado, and we anticipate that this will be the current system. Even as numbers rise, I think they're trying to release kids faster as they identify sponsors. So after an unaccompanied minor is detained and processed by ORR, then they're looking for this sponsor, right? So they give primary priority to parents. Then they go to legal guardians. Then they go to an adult relative, and then they might be looking at a family friend, someone who steps up and wants to take the care of this child. So it's not a legal sort of passing of custody of this child, but it's someone who says, you know, I agree to take responsibility for this minor. They often don't have lawful status themselves. ORR is not looking at whether the sponsor has lawful status. And if no sponsor can be located, then those minors who are detained on the border and maybe in a shelter who don't have a sponsor, they're going through immigration court proceedings while they're in the detention facility. So they call them shelters while they're in detention, is what the reality is. So I just want to stress that the children that are coming over the border, this humanitarian crisis, they are still in removal proceedings, and they are expected to go through this process. They're not afforded counsel, so that's why we need all of you. ICE has stated that, you know, they'll maybe wait to serve the notice to appear on the courts a little longer than they have in the past, so that kids who have arrived in Colorado will just be starting their immigration court proceedings here. But just to flag it for you, if they've spent a number of days, weeks, possibly months in a facility, they may have already started going to immigration court, and a change of venue from San Antonio, from El Paso might need to be done as well, now that they're up in Colorado. Okay. And then lastly, before I turn it over to Ashley, is just to also note that not all minors who are in immigration proceedings are part of this crisis of recent arrivals coming over the border. There are some kids who have been here for a number of years, who are maybe coming into contact with ICE through juvenile adjudications that may end up on this docket as well, so not to leave them out entirely. So those might be kids that you'll see as well.
Okay, so I'm just going to talk to you a little bit about the juvenile docket. The Denver Immigration Court started the juvenile docket in February of 2012 to have a separate day, a separate docket for these kids. EOR has some policies that we'll talk a little bit about trying to make the process for these juveniles be a little bit more kid-friendly, a little bit less scary. And so one of the things that they've done is created this one day for most juveniles to be placed all on the same day with Judge Mimi Sankoff. So all unaccompanied minors and all juveniles who are not riders or derivatives on their parents' case should be scheduled for the juvenile docket, which is generally the second Thursday of every month with Judge Mimi Sankoff. If you encounter a minor who is scheduled on the regular docket, which is quite common because, of course, on the NTA there's no place to put a date of birth, so a lot of times the clerks don't know that the person is a juvenile. The clerks are very amenable to just a call or an email asking that this person be placed on the juvenile docket, which I would recommend doing because I do think it helps kids to see that they're surrounded all by other kids, all in a similar situation, rather than on the regular docket. I think it can be a little bit less intimidating. The court tells us that we have approximately 250 juveniles on the juvenile docket right now. We, of course, expect that number will continue to rise. Just the nitty-gritty of it, the mornings, so you all know at 8:30 is generally for reset. So these are for kids who are coming back for their second, third, fourth hearing. The afternoon is for first appearances. And what Judge Sankoff will do at both of those is at the very beginning, she'll make an announcement that anyone who is there for their first appearance or who has not yet attended the Know Your Rights presentation should follow me, and we go into either the pro bono room, or lately the numbers have been so large, into another courtroom to listen to a brief presentation about their rights during this process, as well as brief explanations of the various types of relief that these kids might qualify for. One thing to be aware of is that right now, in general and historically, Judge Sankoff has been giving these kids approximately 6 months for a first continuance to find counsel. That's been rather automatic when kids go the first time. I think previously it was possible for kids, or I'm told by Katie Glenn, who used to do this, that it was possible to go in a second time and ask for another continuance for counsel. That has not been my experience. In general, when kids are going pro se to their second appearance, Judge Sankoff is requiring them to take pleadings and to answer the question, are you afraid to go home? If that answer is yes, then Judge Sankoff will give them an I-589, and OCC will be giving them a UAC instruction sheet, which we'll talk about and I'll show you an example of, which outlines the process for these kids to file their I-589s. If the kid... I'm sorry, I-589 is the asylum application. Thank you. She will give them the OCC will give them those instructions, and the judge will give them a copy of the application, and then they really are required to file that before their next hearing, or she will deem it abandoned. If the child answers no, that they're not afraid to go home, they have to identify what other kind of relief they intend to apply for, or potentially ask for a voluntary departure. So I just say that so we're aware that these kids are really being processed through, although in perhaps a more kid-friendly environment, also in a rather expedited manner already. As I'm sure you've all heard in the media, there's a lot of push to make these proceedings more and more expedited. So as I said, historically, we've seen kids get 6 months or so to seek counsel. We may see those resets being quicker and quicker, shorter and shorter to find counsel.
I have a question for you.
Yeah.
Do you know if this juvenile docket is something that is unique to Denver, or if this model is used nationally in other courts?
It is not a national model, but we're not the only one by far. I don't have a number of how many, but there are a handful of them across the country.
10 to 15 other juvenile dockets around the country.
Yeah. Any other questions from the panelists? Okay. So we'll do our ask for help at the end, but just to plug it here again, we are perfectly fine with going forward with doing these Know Your Rights presentations at every docket. We do one in the morning and one in the afternoon. But I think we do lose a lot of kids because I'm not able to stay there right then to do their intakes, because then I need to go into the courtroom. So if we had 1 or 2 attorneys in both the morning and the afternoon to actually do an intake right there, I think we would catch a lot more kids that are not able to come out to our office or able to make it work to come in for an intake later. So we all know that most immigrants in removal proceedings are not represented. This is no different for children. Most of these kids are going forward pro se, taking pleadings, having to present testimony, present evidence, applications for relief pro se. I think our youngest kid that we have had with Remain so far is 2 years old. And of course, we have them all the way up to 18. So this is obviously a really daunting process for these kids anyway, and to do it unrepresented is terrifying. Sorry?
The statistic that just got released.
Oh, thank you. Yes. So we just got this morning some statistics that the outcome, if an attorney is present for these kids, in almost half, in 47% of the cases, the child was allowed to remain here in the United States. It doesn't say, if they qualified for asylum or SIJS or what, but about half of these kids were allowed to stay. Kids who had no attorney where they appeared pro se, 1 in 10 were allowed to remain in the country. So it obviously makes a huge difference. As I mentioned, EOR has some procedures to try to make court more friendly, but really the thing that these kids need is representation. You all probably heard on July 9th, the ACLU and some other national organizations filed suit in JEFM v. Holder. It's a class action that was filed claiming that this is a violation of these kids' due process rights under the Fifth Amendment, that it is a fundamentally unfair proceeding to have these kids going up against the U.S. Government Council. So we'll see what happens with that. I don't know of any updates besides that they filed their complaint. I want to talk to you a little bit about this law that I'm sure you've all heard about in the media. I've mostly heard it as this 2008 law that was signed by President Bush that's allowing these kids to stay here. So this is the Trafficking Victims Protection Reauthorization Act. And I'm going to talk to you a little bit about what the law is and what it does for unaccompanied alien children. So there are numerous protections in this law. The first one is what Abby talked about, that these kids, rather than being transferred to ICE or transferred to the custody of the Department of Health and Human Services Office of Refugee Resettlement. One key provision of this law is that rather than, like their Mexican cohorts, rather than being put in a credible fear or reasonable fear proceeding, they have the right to be placed into regular Section 240 removal proceedings and have the right to go in front of an immigration judge. These kids have the right to voluntary departure at government expense. They are exempt from the 1-year filing deadline for asylum, as well as the safe third country limitation for asylum. We'll talk a little bit more in detail about that in our asylum protection, or in our asylum section. One other key provision is that the initial jurisdiction over their I-589, which is their asylum application, goes to USCIS Asylum Office, rather than having to file first with EOR like everyone else who is in removal proceedings. So when you're generally already in removal proceedings, you only get one bite at the apple, right? You have to file it with the immigration judge. If the immigration judge denies your claim, then you go up to the BIA. These kids, whether they have already filed an asylum application with the IJ, and even kids who an IJ has already denied their asylum application, whose asylum application is in front of the BIA, or even those that may still be here who have a ruling from the BIA, all of those kids, they get the chance to file an I-589 with USCIS Asylum Office to get a first crack at the apple there, or bite at the apple, whatever that is. And why is that important? Because, of course, it's supposed to be that a USCIS interview is less adversarial and is supposed to be slightly less scary. These asylum officers are also specifically trained in children's claims and in interviewing techniques for children. There are protections in place for these kids for how their asylum interview is supposed to go as opposed to an adult. So it's very important that they are able to take advantage of this special protection that they have. And another thing that the TVPRA did was expand the definition of special immigrant juvenile and expand who is eligible for that, which Abby will talk about in her section on SIJS. So who is an unaccompanied alien child? Is it just a child, as in under the INA, somebody who's under 21 and unmarried who comes in without their parent? No, because that would be too consistent and make too much sense. So we have a whole separate definition for who is an unaccompanied alien child. It is a person who has no lawful immigration status in the United States who is under the age of 18, not 21, under 18, with respect to whom there is no parent or legal guardian in the United States or no parent or legal guardian in the United States available to provide care to them. One other thing I wanted to touch on, well, no, I'll wait. Never mind. Okay, so why is it important, this definition? Getting the label of an unaccompanied alien child, or UAC, doesn't provide lawful status, right? So why does it matter if a child is given this designation? Because it's that designation that triggers all of these protections that we just talked about under the TVPRA. They have to be designated an unaccompanied alien child in order to qualify. So that means children who make it across, who aren't detained, maybe they're under 18 too, and maybe they don't have a parent or legal guardian here to take care of them, but you have to actually have that designation as a UAC for those protections to kick in. So one of the major protections is this difference that we just talked about of filing your asylum claim with USCIS. Who gets to file their asylum application with USCIS? Do you still have to meet that statutory definition of unaccompanied alien child? In other words, do you have to file your application with USCIS before you turn 18? Can you still file if after you get out of ORR you're released to a parent or legal guardian? In May 2013, USCIS answered those questions in a very good way. They answered the question to say basically once you get that designation as a UAC, you are always a UAC. Even if you turn 18, even if you are placed in the custody of a parent or a legal guardian, you are still a UAC and those protections still apply. USCIS will still take jurisdiction of that asylum application. So that's really important to understand.
So Ashley, just a question. Who is able to make a UAC designation?
CBP, ICE, OCC, all those acronyms. I don't believe anyone within ORR makes the designation. It has to be, most of these kids, the vast majority we've seen, I don't know if we've seen anyone that it wasn't CBP who made the determination, because that determination is made within the first 72 hours of a child coming into the country. So under the Flores settlement that Abby touched upon, CBP has 72 hours to transfer a child to the Office of Refugee Resettlement Custody. Within that 72 hours is when the kid will get the UAC designation. So even if a week later, or more likely 1 month, 2 months later, the child is eventually released to a parent here in the United States, they already got that UAC designation within the first 72 hours of being here.
And what documentation is given showing that they've been given that designation? How do we know that?
Okay, thank you. You're helping me segue so perfectly to my next. One of the things I'm gonna show you an actual example of when it's OCC giving you that, but in general, most of these kids and their sponsors who are gonna come into a consult with you are gonna have a manila envelope with their name and their A number really big on the front of it, and it's gonna have all of their important paperwork. It's gonna have their NTA, and it's gonna have an ORR verification of release form. It's gonna have their photo on the top left. I'm sorry, I should have taken a slide of that form, but it has their photo on the top left, and it says Office of Refugee Resettlement Verification of Release Form. It has the child's name and date of birth, their photograph, and that this child has been designated an unaccompanied alien child. That's a super important piece of paper. You can file your asylum without that paper, and I'll talk about that, but the best thing to do is to file with that paper.
Just real quickly, yeah, I think we're starting to get some questions from the audience. Would you like to answer questions now, or we can hold it until?
If it's okay to hold until the end, I just want to make sure Abby has a lot to cover as well, and I don't want to bogart her all the time.
So I promise we will leave some time at the end for questions. So please hold your questions until the end.
Sorry, thank you. Unless, of course, it comes from my panelists saying, what is an I-589?
The peanut gallery.
Right. Okay. So one quick note, we talked about that the TVPRA waives the 1-year filing deadline for these kids. However, all of this is a really new and evolving area of law, right? And we're proceeding only off of a USCIS memo for a lot of these procedures. So if possible, what we do at Remain and what we strongly recommend is to still file within 1 year of entry, if at all possible, because it's not actually clear from the USCIS memo or from anything else if the 1 year bar is waived forever so long as you ever got that UAC designation, or if it's only waived so long as you still meet that statutory definition of a UAC. In other words, you're still under 18 and not with a legal guardian. So it's still very much our recommendation to file within 1 year of entry. And if that's not possible, to certainly file within 1 year of the loss, within 1 year of when they fell out of the statutory definition. In other words, within 1 year of being reunified with a parent, or within 1 year of turning 18. I did cite on here those wonderful memos that came out from USCIS in 2013, as well as an FAQ on that. So you'll want to look at those if you're filing one of these. So the actual nitty-gritty of the asylum procedures, we've talked about 12 times now that USCIS has initial jurisdiction. So you're going to file it with USCIS Nebraska Service Center, as long as you're filing from here in Colorado. We just talked about this, that they probably have paperwork, including that verification of release from ORR custody form that will prove that they were designated a UAC. If you don't have that, or the sponsor doesn't have that, there is a quite easy form to do a FOIA to the Office of Refugee Resettlement, and generally those come back in about 30 days, and that will have all the paperwork that you need. If you have questions about how to do that, please do email us, because they like a specific form. It's not a regular FOIA request. So what you want to do, so you've identified this kid is in removal proceedings, was designated a UAC, has a fear of return to their country, and you are going to file an I-589 asylum application for them. What you need to do is get the UAC instruction sheet from the Office of Chief Counsel at the master calendar hearing. In general, they will offer it to the child if the child answers yes, they are afraid to go home, but you want to make sure, as their counsel, that they do get that. This is what it looks like. Instruction sheet for an unaccompanied alien child in immigration court to submit an I-589 asylum application to USCIS. It says you are receiving these instructions because you appear to be an unaccompanied alien child. What ICE OCC is doing right now is making their own nifty little notation on there, crossing out you appear to be an unaccompanied alien child, and putting you were designated an unaccompanied alien child at the border. This is for all kids that no longer meet the statutory definition, who come to court who are already over 18 or who are with a parent or legal guardian. They will make this notation. We don't really know the impact of that notation. So far, USCIS is still receiving those applications fine. But the concern is, we talked about that once designated a UAC, it appears always a UAC. The exception to that is if there is an affirmative act by ICE or HHS or anybody else, CBP, to revoke that designation. So we're hoping that these little designations, these little notations that ICE is making on them, are not going to be sufficient to count as actually revoking that designation. but that remains to be seen. So you file the I-589 asylum application with the Nebraska Service Center following the very clear instructions here in this sheet that you'll get about how many copies to file and with what documentation.
So Ashley, and yet another follow-up question. Who has the authority to revoke a UAC determination?
It is HHS, ICE, CBP, so Housing and Health and Human Services, ICE, or CBP can terminate the UAC finding. But as of yet, in 1 year of filing these, Remain hasn't seen any revoked, so we don't really know how that will play out. So you will file with the Nebraska Service Center with that sheet, with that ORR verification of release form showing that the kid was designated a UAC. We generally also file with proof of age, like a birth certificate if they have one. Just a real nuts and bolts, nitty-gritty word to the wise is sometimes these applications are getting misprocessed or misfiled as a defensive filing, particularly for kids that maybe already filed their application with the immigration court and now they're filing one with USCIS. USCIS seems to be a little confused about what to do with those sometimes, and they will actually route it as a defensive application to the court, and you'll be wondering, where the heck is my receipt notice? What's going on with this? So the Houston Asylum Office has suggested this funny language to put in your cover letter. TVPRA filing, that part makes sense, right? PRL, I have no idea what that means. And forwarded to ZHN. I don't know who ZHN is. But this is supposed to help them, magic words, to know what to do with the application and hopefully avoid the shit show of trying to track down your application or having to refile it. So as long as it gets routed correctly by USCIS, you should get a receipt notice from the Houston Asylum Office, one of those little half sheets, and you'll get a biometrics notice from Nebraska. Those generally happen within a couple of weeks. And then at some point, you should get an interview notice. We first started filing these when these CIS memos came out last summer. We have yet to get an interview notice. As we talked about, there's a lot of push to expedite these things, so they might start coming fast and furious. But at this point, no interviews for over a year. I want to just make one little note about these asylum cases. Having just very recently come over to Remain from 4 years with Ms. Laura Lichter in private practice, these look really different than what I at least was used to seeing in private practice. Most of these kids are fleeing because they're terrified of the gangs in Central America. Some of them have lived through really, really horrific things that have already happened to them. Some of them are afraid that the things that have happened to their cousins, brothers, sisters, whoever, is going to happen to them too. You may all be aware it is a sad state of affairs for asylum cases based on fear of gangs, based on gang-based persecution. Just because a kid's asylum application is not very likely to win under the current state of the law does not mean it's a frivolous application. The definition of a frivolous application is that it contains a deliberate misrepresentation of a material fact. That means that a kid is lying about something material in their application. It doesn't mean that they are truly scared because of what happened to them or scared of the gang, and it's frivolous because they're unlikely to win because we have bad case law right now. So I just wanted to make a note about that because I think it can be hard to evaluate these asylum claims with maybe private practice eyes on, knowing that you don't want to charge a client a whole lot of money usually to do an asylum case that doesn't have very much chance to win.
And again, we're holding questions until the end. Thank you.
We'll do our pitch for what we need at the end, but one particular thing that would be great, particularly Mark Barr, I'm talking to you, and Laura Lichter, and Jeff Joseph, and whoever else is in here that has a lot of experience, but people that are willing to take an asylum case that has the potential to go to the 10th Circuit or beyond to try to change some of that bad case law that we have for gang-based persecution would be wonderful. And I'll turn it back over to Abby.
All right, special immigrant juvenile status. Whew. We could spend 2 hours just on this topic. So, it's 12:45. I will go through it. I might go through it pretty quickly. We're always available as, resources for these types of cases because SIJS is complicated. So special immigrant juvenile status is a form of relief that you may see a lot of these children be eligible for. It's laid out in the INA, in the regulations, and then there are a series of memos that have come out as this area of law has developed that are very useful, especially when you get RFEs or NOIDs or have an officer that is misbehaving in your interview, like I had yesterday. So the purpose of special immigrant juvenile status is to allow abused, abandoned, and neglected children to apply for lawful permanent residency. It was created in 1990, and it was recently amended in that very important TVPRA of 2008. So it's a funny little area of law because it is an immigration benefit, but it starts in a juvenile or a state court. So you have to get what is called a predicate order or an SIJS order out of a state court in order to be able to apply for the immigration benefit to USCIS. Okay? So a juvenile court, we can start with that, is a court located in the U.S. having jurisdiction under state law to make judicial decisions about the care and custody of juveniles. So that encompasses a whole lot in Colorado, and I'll talk about what is a juvenile court in Colorado. We've done a lot of advocacy to convince judges in Colorado that are not maybe in the Denver juvenile court that they are in fact a juvenile court as this law sort of thought they would be. So family law, allocation of parental responsibilities, guardianship, delinquency. So the core requirements of special immigrant juvenile status is that the applicant is under 21, unmarried. They have been declared juvenile court dependent, or, so this or is important for our juvenile courts making these orders, they have been placed in the custody of an entity that was appointed by the court. Okay. The next finding that we're asking the state court to make is that reunification with one or both of the minor's parents is not viable due to abuse, abandonment, neglect, and then or similar basis under state law. So Congress tried to make this as expansive as possible by putting in all of these ors, by saying similar basis under state law, by making the definition of juvenile court be rather expansive. Again, sometimes in these predicate orders, the way that Congress envisioned things and the way that state courts, say, what is this that you're trying to make me sign, is pretty challenging. The next finding that you're asking the state court to make is that it's not in the minor's best interest to return to their country of origin. And lastly, that the court will maintain jurisdiction until the final lawful permanent residency status is granted. Again, jurisdiction, complicated issue. Okay, so step one is that predicate order. In Colorado, the most sort of what would pop into your head, I think, is dependency and neglect proceedings. That is a court that is truly charged with trying to determine these things: abuse, abandonment, neglect. So it could be kiddos who are in foster care. It could be young people who are in what's called the URM program, the Unaccompanied Refugee Minor program. The URM program is sort of under this Office of Refugee Resettlement. If a child is crossing the border and they have been designated as a victim of trafficking, if they meet certain other definitions of being an especially vulnerable minor with no support in the United States, then they can be put in this URM program, so Unaccompanied Refugee Minor. Most of the kiddos from Central America do not get placed in the URM program. URM, Unaccompanied Refugee Minor. It's basically like a federal foster care program. Okay, so most of the kids from Central America are not part of that program, unfortunately. But dependency and neglect proceedings, who decides to open those, right? It's the County Department of Human Services. Our counties do not want to open DNN proceedings on kids who are undocumented. That's the reality. They're not going to open DNN proceedings in most of these cases. So luckily, that definition of juvenile court does not limit us to DNN. We can look for these predicate orders if a juvenile is in delinquency proceedings. Kind of fascinating. If they go to probate court and they're looking for a guardianship, right? So they've been released to a sponsor, a brother, a sister, an aunt, an uncle, a grandparent. That person can apply to be their guardian, and you can look for that predicate order from the guardianship proceedings. Family law court. So in Colorado, it's allocation of parental responsibilities, not custody. This is where we're looking at that one parent. So I don't know if you heard me say, it's reunification with one or both parents is not a viable option. So even if they're being released to a parent and they're now with mom or with dad, but the other parent subjected them to abuse, abandonment, or neglect, they can still get this predicate order. So in those one-parent cases, most of the time it's the parent that they are with who didn't subject them to abuse, abandonment, or neglect, asking for custody of that child, and then you're looking for the predicate order. And it's also possible in adoption proceedings to get this order. Okay? For those of you who maybe will go with David Simmons as he treks around out of state to these various facilities, meeting with maybe some of these unaccompanied alien children, UACs, if they're in detention in an OR facility, they can still look for this order as well. That would be the specialty of organizations like ProBar in Texas, some RAICES, all of these organizations that are working in those facilities. But just to flag it that it is possible. It's not just after you get released.
Abby, sorry to join
Sure.
the peanut gallery, but in Colorado, is it possible to get those orders under 21, or do they have to be under 18?
Very good point. Thank you. So the pressure that we face for a lot of these cases is that these state court proceedings, a lot of them end at age 18 in terms of jurisdiction. So guardianship is pretty 18, boom. You're not asking for guardianship of a minor in Colorado unless they're under 18. Allocation of parental responsibilities is a little more malleable, might be up till age 19. But in most cases, this is up until age 18. Okay? Dependency and neglect, that is our biggest opportunity. So most of those cases are open until age 21. Okay. All right. So they've got to be under the jurisdiction of the court. So that's why I say they won't open DNN, so you got to find another way to get into the court. So that you can show that they're under the jurisdiction of this juvenile court. So that's the first thing. Then you've got to show some hook of abuse, abandonment, or neglect. So this is another complicated area because the terms abuse, abandonment, and neglect are determined by state law. They're not defined in the INA. So you're working with an immigration benefit, but you're trying to make it fit with whatever state system that you're getting that predicate order. So you've got allocation of parental responsibilities under one section of Colorado revised statutes. You've got DNN under another section. You've got probate under another section. So you're trying to look for hooks in that state court, what they're working with and their language of the courtroom to try and convince them that this order really is something that they can sign, really is something that's under their jurisdiction. Luckily, we do have this other similar basis under state law, so it gives us pretty big leeway to make these arguments. So not always easy. All right, best interests. You're looking to show the court, what the child is facing if they're not able to get this order and then apply for an immigration benefit. So you're looking at, what they would face if they were returned to their home country, all of, the gang-based violence that they've talked about. But you can also cite things like they have no family to go back to. They made the decision to make this journey up to the United States because of everything that they went through with their family there, or because they didn't have any family support. You can also cite educational opportunities here. The fact that they've maybe been through a traumatic situation and need support. And then continuing jurisdiction. So right now, this state court has to maintain jurisdiction over this child until you're done with the whole immigration process. So currently it's, I would say, about a year because of the way that the interviews have been delayed at USCIS. If they age out of that court, so if you've gotten a guardianship for someone under 18 and then they turn age 18, how is that court going to maintain jurisdiction for you to be able to apply to USCIS? Well, we add language in our predicate orders about maintaining limited jurisdiction that in most cases allows the predicate order to still maintain its validity in terms of jurisdiction. Okay, so step 2, after you get this predicate order, or after a family law attorney, an expert in family law has gotten this order, you're going to do the immigration forms. So it's an I-360, okay, and then an I-485 application for adjustment of status, so that's the residency application. Okay. Step 2 looks different if a child is in immigration court proceedings. Okay. In Colorado, you have to do it in parts. You get the predicate order, you apply for that I-360. That designates the child as a special immigrant juvenile. You take the approval back to Judge Sankoff and you say, this kiddo has been approved as a special immigrant juvenile. We'd like to terminate proceedings. After the proceedings are terminated, then you're filing the I-485 with USCIS and adjusting their status. Other jurisdictions, other USCIS offices do it differently. I've heard that other people don't have to go through that daunting process. They can file it all at once, which is the way things are if someone is not in proceedings. But in Colorado, right now, you gotta do all those pieces and parts. All right. Other considerations, I would say I'm just going to talk actually about number 2, and then I'll just touch on the last one. But the state court, under this law, when they passed it, is the entity that is specialized, trained, equipped to make these best interest determination about a child. Who should have custody over them? What is in their best interests? And not USCIS. So just a warning, USCIS often likes to go behind that order and poke around in the facts and maybe act like they should be making these decisions and not the state court. I encourage you to push back on USCIS because that is not how the law was drafted. That is not what's set out in all of the memos. So even though they want to do that, they shouldn't. They are prevented to do that beyond looking for certain supporting facts. And then the last thing I'll touch on for SIJS, because we are running out of time, is just to flag this. This is a hard thing for a lot of young people who you say, we have this fabulous opportunity for you to get a green card, lawful permanent residency in the United States. But if you apply as a special immigrant juvenile, you cannot petition later for your parents. So even if there's that one parent, right, or one parent that they reunified with and they've come to be with because they suffered abuse, abandonment, neglect from the other parent, they can never apply for that parent to get an immigration benefit. So it is lawful permanent residency, but it comes with some caveats. Okay. juvenile adjudications come into play in all areas, right? And when we're looking to get lawful permanent residency, when we're looking at admissibility issues. Just to lay this out there, I know that most immigration practitioners know, but juvenile adjudications are not convictions for immigration purposes. Okay? They can be used as a discretionary factor, but officers should not be considering those convictions. Resources here, SAJS is complicated. I know it's a lot of information, but there are a lot of resources out there. Okay, so we've got about a half an hour left. I will leave, so I'll talk about U visa, T visa in just very general terms, and then I'll turn it over to Ashley about how we work with kids. Okay, U visa, most immigration practitioners are familiar with it. It's for victims of certain crimes that occur in the United States. Because we're looking at addressing this humanitarian crisis, and most of these kids are going to be coming up over the border in their recent entrance, they probably won't qualify as a principal applicant, as the victim of a crime in the United States. Maybe they'll be victims of crime when they're in the custody of CBP or ORR. We've heard some pretty horrific stories about that. I don't think that you're going to get a U visa certification out of those facilities or those entities that are charged with governing those facilities or monitoring those facilities, but it could be.
Hey, we could sure try.
It could be. So then you're looking at whether they're a derivative. So maybe they've reunified with mom, with dad, and mom or dad or somebody else in the family has been a victim of crime here in the United States, and they could be included as a derivative on that application. So just to flag the U visa opportunity. T visas, also a thing that we could talk about for hours and hours. T visas for victims of human trafficking. You're looking at sex trafficking, and you're looking at labor trafficking. A lot of these kids have been through some pretty difficult things in the journey, but sometimes those really traumatic stories can turn into a T visa. So what we have seen recently is a number of kids who are being asked to carry drugs over the border. I say asks, but it's really, they are forced, they are coerced, they are threatened, and they are continuing to be threatened even when they're released out of ORR. ORR gets contacted. I've had certain juveniles who said, ORR, got contacted by these people that I didn't even know who they were, the people who forced them to traffic the drugs over the border, so to continue their trafficking. So forced drug trafficking, we argue, yes, is a T visa. There are several organizations, including Remain, that are putting forward T visas in this context as a form of labor trafficking. So I think it's possible, and it's a viable option. Also to flag on this slide, before I turn it over to Ashley, is that the reasonable request for assistance from law enforcement, compliance with that is a requirement for adults. If you're under age 18, that requirement does not apply to you. So you don't have to comply with any reasonable requests. You don't have to reach out to law enforcement. It's not a requirement if you're under 18. And that continues if the trafficking happened while you were under age 18, and now you're older than 18. It's not like once you turn 18, then you have to cooperate with law enforcement. If the trafficking occurred under age 18, then that should still adhere. Okay, I didn't know, I forgot about this slide. Okay, ORR eligibility letters are also an option for kiddos under age 18 who have been victims of human trafficking. This is something that you can apply for. It is not for an immigration benefit, but it's for a whole package of other benefits that are provided for victims of human trafficking. You have to give a sort of a summary of all of the indicators of trafficking for your young person. It's processed through ORR. If ORR does designate your young person as a victim of human trafficking, then they can get a whole lot of benefits. Medicaid, they can get mental health therapy paid for. They can get, help me out here, what else? Where's Pat? Cash assistance. It's sort of like the package that refugees get. But it can be something that really makes a difference in just their everyday lives. Okay. All right. Oh, gosh. Do you want to do this one? Okay. In addition to relief options, we also want to point out that these cases are ripe for other types of litigation, right? So looking at options for terminating procedures, or terminating proceedings, I should say. So you are screening them for relief, but as the numbers have spiked and as we've seen, with the cases that we already have, the way that they're getting screened and questioned by CBP is very problematic. So looking at suppressing statements, looking at improper service of the NTA to terminate proceedings, looking at whether the I-213 is enough to establish that they're inadmissible, because is it enough to establish alienage? So there's a practice advisory in the works from Kristen Jackson from Public Counsel on these issues, so look for that. But you're also balancing, if you do terminate proceedings, how does that affect your client's options in terms of relief? DACA and prosecutorial discretion are the two last things, I promise, that I will flag for you. DACA, probably not an option for most of these recent arrivals, but don't discount it, right? You might have a kid who has been apprehended in the interior that has ended up on the juvenile docket, who has the time of residence here in the United States. And then finally, prosecutorial discretion. It seems like if you have a 2-year-old who has to sit on someone's lap when they go up in front of the immigration judge, should be able to get their case at least administratively closed, right? It should happen when ICE is looking at serving an NTA, when they're looking at a 4-year-old, right? It should be happening, and I think we still need to push it in every way possible. What our prosecutorial discretion requests have come back with the stamp of these are recent arrivals, and we are just not offering, ICE is saying we are just not offering prosecutorial discretion to recent arrivals. So that is their blanket statement right now, but I think that we still need to push. If they had a critical mass of all of these requests on behalf of these kids that goes up to OPLA, maybe we could start moving them on this issue. So that's the last thing I'll flag. I'll turn it over to Ash.
We're not done.
They like you.
Okay.
When you do your little...
I really am going to speed through this last part, though, since I shut down so many questions the first time I was up here. So most of this is just common sense, but I just wanted to talk to you guys briefly about how working with kids, with the 2-year-old, the 4-year-old, and even the 17, 18-year-old is different than working with the adult clients that you might be more used to working with. Their ability to participate in the court hearings and the interview, even in interviews and consultations with you in your office is very different. In particular, most of these kids, or a lot of these kids, have been through extremely traumatic situations in their home country that motivated them to come, as well as the whole process of crossing the border and being detained, transferred around, wondering who they're going to be released to and when, and then they're in your office. And so just to keep in mind that their age, their lack of education, their having been through such trauma can really, really impact their development. So you might be thinking, oh, this is a 17-year-old in front of me. I can talk to him like I would my own 17-year-old, or like an adult. But really, in a lot of these cases, you'll see that they might present actually as much younger than the age on the form. And to keep that in mind with how you communicate with them, how you interview them about the trauma that they've been through, who you have present when you talk to them, things like that. I wanted to touch on these minors' capacity to consent. Of course, according to the regulations, parents or a legal guardian can sign forms for kids who are under 14. Parents can accept notice for kids, but just bear in mind whether the kids' interests and the parents' interests are aligned. And most importantly, I would say keep in mind that the child and not their parent, not their sponsor, not their older brother who's there as their sponsor, the child is your client. The child is who you need to communicate with, give notice to, get the facts from, decide what they want to do. Of course, you can wrap in family members, sponsors, to help gather documents, to help explain things to the child. Certainly, it can be helpful to have another trusted adult there with the child, but please bear in mind that the child is actually your client. Oftentimes, we find that the family members or sponsors need a little reminding of that sometimes, that it is the child who's our client and it's our child who, or the child who gets to make these decisions, or who we need to talk to in private about some of these things. And that can be hard for these adults who are used to sort of handling things for the child. One important thing to note is that these kids have been through a lot of professionals, a lot of adults, a lot of offices in the last few weeks or months before they come to your office. They've been probably passed around from, parents to their coyotes or whoever, to the CBP, to ORR, who has caseworkers for them, who has paralegals or legal advisors to them, who has social workers, who has teachers, all of these adults in the kids' lives. So it's very important that you explain very clearly to the child who you are and who you're not, that you don't work with CBP, that you don't work with immigration, that you are not also a social worker, that you are their attorney, and here's what you can and cannot do for them. It's also super important to loop in people who can provide other services to these kids outside of the legal help that you will hopefully be able to provide for them. I think that's actually my next slide, so I'll go back. So just other service providers can be super helpful if these kids, if the sponsors, a lot of these sponsors are, for a 16-year-old kid, it's their 20-year-old brother who's their sponsor, or their 18-year-old brother or sister. A lot of those older kids are new to the United States themselves. Most of them don't speak English either. So, they may not have a whole lot of awareness about how to get the child enrolled into school, how to get the child access to medical care or perhaps mental health care, things like that. So super important to keep in mind to pull in other service providers for the other needs that the children have outside of their legal needs. You all have this slide. We don't need to go over it in detail, but just some child-sensitive interviewing techniques, basically just to remind yourselves when you're talking to them that you are talking to a child, and to phrase your questions differently than you would to an adult, and to be really sensitive of their limitations in talking particularly about the traumas that they've been through. Abby mentioned that it can be difficult for kids to know that they'll never be able to petition for their parents for SIJS. What I find more difficult for them is having to say, yes, I was abused, neglected, or abandoned by my parents. Or, I might be saying, well, actually, your parent allowing you to cross the border by yourself at age 7 qualifies as an abandonment under Colorado law. And that's difficult for them to use those labels of abuse, neglect, or abandonment when they're talking about their parents. So just to be sensitive to those kind of issues and not just throw it out as a legal term and leave it, but to really process it with them in a way that they can understand. One last most important slide before questions is how you can help. So as I mentioned, I would really love to be able to conduct more intakes at the day of the docket. So an intake is just like a regular legal consultation to screen for these types of relief, to answer their questions, and see what they qualify for. So if attorneys could volunteer to come and help with that, to be available to screen the kids that day so that they don't have to come to my office later, that would be great. What would be even more fantabulously great is if attorneys could volunteer to take at least one case pro bono. As we mentioned, these numbers are already crippling. You are looking at the Remain Children's Program right here. It's Abby and I, and that's it. So the vast majority of these kids are having to go forward pro se without any representation. So we really, really need help. There are some sign-up sheets that hopefully you all got when you came in, where you can indicate what you're interested in helping with, either just doing intakes at the docket or taking a case pro bono, what kind of case, what your availability is, etc. For any of you that do family law, have any interest in family law, would like to open a new family law practice, anything, family law, our desperate need right now is to get those predicate orders for SIJS. So that means going into a family court to get the allocation of parental responsibilities or custody order, to get the guardianship order from the probate, to get the predicate order that Abby talked about. We have tons of samples. We have mentoring that we can provide to you. We will help in any possible way, but for anyone that's willing to help get those family court orders, that is a huge need that we have right now, along with representing the kids then in front of the court and USCIS, of course. As we mentioned, attorneys willing to take asylum cases that might need to keep going up and up. And also, I think Lisa and David might talk about potential litigation around the changes that are being proposed to the TVPRA, which would basically strip the protections that I explained to you for these kids and make these kids treated, make the other than Mexicans, the OTMs, treated like Mexicans. So basically to lump everyone in to get credible and reasonable fear, interviews with CBP, and then get expedited removals home. So obviously if those really scary proposals come true, then we'll need some help with litigating that. And then I'll turn it over to Lisa and David, I think, to talk about any out-of-state opportunities on the border.
All right, so we did promise that we would leave at least a few minutes at the end for questions, so I am going to make my statement brief. I'm going to talk a little bit about what's going on at the national level with AILA and coordination, and also kind of what's going on legislatively. The big caveat that I have right now is that there still are a lot of unknowns. We simply don't have enough information to be making some of the determinations that we need to be making in order to provide a rapid response and gear up to staff the borders, basically, to volunteer and help these kids out. So there's a lot that's still kind of up in the air, and that we're all trying to figure out before I think we'll be able to come up with some solid plans. But I do just want to, I said this at the very beginning, but I just do want to make a note that in this room right now, I think we're almost at standing room capacity. All of the seats are filled. The volunteer response to this crisis that is going on in our country right now has just been absolutely tremendous, not only here in Colorado, but nationally. AILA National is reporting that they have never received the level of response that they have at this point in time for any other issue that has come up in their history. And so the bottom line is I think that there's a really strong statement that Americans really feel very strongly about this issue, and that we are very committed to providing due process to these kids. And if everyone in this room can step up, and nationwide step up, I think we really can make a difference in this. And in terms of legislation that is going on right now, obviously the appropriations bill is working its way through Congress. It's not going so well. It's kind of stalling out. And I think one of the main issues is that of that $3.7 billion that has been requested, most of that has been earmarked for more enforcement and detention activities. There's only a very small amount in that bill to hire new immigration judges, which we're all in favor of, and to support legal orientation program, LOP providers, and also direct representation. So even if that bill were to pass, there would still be some major problems, and basically gearing up for capacity to provide representation, it's really going to fall on all of us, and we're all going to need to make a real serious pro bono commitment to that. And finally, I just would say that I think there's also a lot of interest outside of the immigration bar to step up and provide pro bono services as well. So I'm going to turn over to David.
Like Lisa mentioned, we're at the very early stages of identifying what this crisis really looks like and how we respond. It's kind of like when the Forest Service gets a report that there's a bunch of smoke up in the mountains and they haven't quite figured out where the fire really is yet or what resources they need, and they've got some ideas. We're very early into this, and there are opportunities that are going to arise that frankly don't exist yet because the organization isn't set up to handle the volunteers. There are 3 places right now, if you have a burning desire to, or even if you're just really interested, to get involved in this situation and do hands-on representation right now. There are at least 3 places where you could go. Catholic Charities of the Archdiocese of Oklahoma City is handling the situation in Fort Sill, Oklahoma. Fort Sill, as was mentioned, has 1,200 detainees. The Archdiocese down there normally handles 1,200 cases a year. So they have an entire one-year caseload sitting there. I would say they are screaming for volunteers. They put out a notice, please, please come and help us. We need people to represent these kids.
Road trip, anyone?
Yeah, road trip to Oklahoma City in the summer during tornado season.
Summer vacation?
Right. I would suggest contacting or going to their website, which is http:// just like always, helpkids.catholiccharities.ok.org. helpkids.catholiccharities.ok.org and see what they've got.
It's not in the PowerPoint.
It's not in the PowerPoint. You got to write it down or come see me afterwards. So one more time. I thought you took better notes than that when you were in my class. Sorry.
And we can put that out on the listserv.
I like Maria. That's why I said that. Helpkids.catholiccharities.ok.org. Second, been around for longer than dirt. I was a brand new attorney and was sent by the Colorado chapter down to Pro Bar in Harlingen, Texas. This is an ABA Texas bar and a couple of other organizations run program. They have standing paralegals who do intakes and case workup. They want attorneys both short-term and long-term. If you have a burning desire to go to the South Texas Valley and Harlingen.
No pun intended.
Yeah, no pun intended. They do have a children's center there. The phone number to contact is 956-365-3775. Their email address is imcenter@americanbar.org. Like I said, it's an ABA organization. They are very well organized. That's a place where you could literally call them up, be on an airplane tomorrow, and be doing a case the very next day, and the case would be organized and prepared for you. So that's another opportunity. Third, and I'm not as sure of the organization, but again, they've been around for a while. The Diocesan Migrant and Refugee Services in El Paso, Texas, has an existing program for working with unaccompanied minors. They can be reached at 915-532-3975. So those are 3 opportunities right now. What's coming? We have not unaccompanied minors, but children with parents currently in Arista, New Mexico. Arista, New Mexico is about a 3-hour drive from the nearest point of civilization, and more important, about a 3-hour drive from the nearest legal services providers. There is nothing out there.
Yeah, and ironically, it's just outside of Roswell, where all the aliens are.
Oh, don't get me started. There is an immigration attorney in Albuquerque who is working at getting something set up. It's very preliminary, but that is something that's probably going to be coming up. Now, that assumes that we don't get a whole bunch of people dropped here and don't have to go into response mode. And I would strongly urge people to consider this in addition to and instead of working here in Colorado with Remain. There are certainly, the American Immigration Lawyers Association has a Texas chapter that also covers Oklahoma, if Texas wasn't big enough, that is stepping up with the Fort Sill situation and maybe dealing with some of the others as well. But there's some opportunities right up front. Stay tuned because this is a developing issue. There are a number of agencies, including AILA, that are working together to develop further programs and further opportunities. And I think I'm done, and are we ready for questions?
Yeah, let's open it up for questions. Right here first.
Okay, so my question is about aging out of SIJS and the jurisdiction of the state court. Can you just speak in general to that at all and things that we can do, if anything? Because I've got a kid that I think the jurisdiction is going to end at age 19, and I'm pretty much at the 1 year point from when I filed SIJ. So I'm pretty worried about
So the
jurisdiction.
TVPRA of 2008 has an age-out protection. So as long as the I-360 and the I-485 were filed before age 21, there's an age-out protection for that.
Okay.
Okay? If you have the limited jurisdiction language in your order, that's the best. Even without that, that's where you look for it's called the Perez-Olano settlement.
Okay.
So that's a class action suit that was a few years ago that should provide protections if in that situation where a kid has gotten the order under 18, turned 18, and now what do you do? So that should provide your fix there.
And just a quick follow-up,
Sure.
sorry. How long are you seeing the I-360s taking for interview?
I would say, 3 to 6 months after you're filing
Six
the
would be long.
I-360.
And how long for a decision after the interview?
Usually after the interview, you should get a decision quite quickly, although you have the outliers, right? So we had one case that we had for an entire year sitting there with poking them every month. And anyway, should
Jessica.
be within a month.
Jessica, you're next. She has a burning question, I can tell.
Well, so it's at the beginning stages. Abby, I know you gave me that phone number at one point. I don't have it anymore.
Yes.
Where parents can try to locate their kids if they're lost in the system at the border.
Yeah.
If you don't mind giving that again. And then I have another question about how bad or how good does a sponsor that's willing to step forward and sponsor their little brother, little sister, whoever, do they have to be before it gets a little bit dicey? For instance, like if it's a 20-year-old brother that's crossed the border a million times with his own in absentia order or something, like I know you said they don't care about immigration status, but do you have to submit anything, a birth certificate, a criminal background check, anything?
Yeah. So they are screening sponsors. You do have to do a background check. You usually have to submit fingerprints to do a background check. And I believe they have to be at least 21 in order to be a sponsor. To be released. So if an unaccompanied minor was released to someone, I think they have to be at least 21. But they are looking at who's the best. So that's ORR's determination. I think that they're looking to make sure that they're not releasing them to an uncle who might be their trafficker. Things like that. But it's not always the most thorough process.
So I'll see if I can flip back to it too, but it's on the second slide in your PowerPoint. Children in custody is the ORR hotline for parents. It's 1-800-203-7001, and I'll put it back up here, but that's a hotline that you all can call too. I've called it, or parents can call. It's bilingual, staffed 7 to 7 or something like that all day. And what they do basically is just take the minor's information and the parent or relative who's calling to inquire about where the child is, they just take that information. They can't release any information about the minor over the phone. But if the minor is in fact in ORR custody, then that hotline will pass the information on to the ORR facility, who will then get in contact with the caller to say, yes, we do have the minor here, and here's what you need to do in order to get them released. As we mentioned, that's supposed to happen. CBP is supposed to transfer them to ORR within 72 hours because of the mass numbers. We've definitely been hearing cases where it's taking much longer than that. I had a mom that couldn't find her 7-year-old for over 3 weeks. So it's taking a long time sometimes for parents to get, or people to get notified where the child is.
Okay, so I'm going to do Laura in the back.
Sorry, you should just let us do questions so we don't have to write long lists. So a couple of things. Can we pool resources? One, just suggestions, if we're all handling similar types of cases, we're involving, a gang-related claim in El Sal, people are going to have good materials. Let's be smart about this and not reinvent the wheel. So if you do have good information, let's get it to a central point of contact so that people can use those materials. Also, I wanted to suggest if you have minors, the true kind, like the little 2-year-old on your lap, we're worried about those cases going forward. Do put it on record that you've made a PD request. Assume that OCC will say no. This thing is politically just untouchable for them. They ain't gonna say yes. What do you do next? Use MAM, matter of MAM for mental health cases. Being a minor is a disability. That's the litigation theory underlying the class action suit that's going on in Seattle. And we may even want to look at expanding that to this jurisdiction. But I want to make sure that people do not try to reinvent the wheel on these cases where we can actually help each other out and put good materials together. I think that'll be really useful.
Thank you so much, Laura. Those were fantastic comments. And I think we had a question back here.
I just wanted to let everyone know, if you do come in contact with someone who needs help with the sponsor paperwork and fingerprints, you can refer them to Lutheran Family Services, Rocky Mountains. They have a person, we have a person who is dedicated to helping them with that paperwork and complete the fingerprints. And we're the only office in this section of the country. So just so you know, Lutheran Family Services can help the sponsors complete the paperwork and the fingerprints to get custody of the kid.
Great. Thanks. Unfortunately, we're out of time right now, but before we end, I'm going to call up Joy, who has a news-breaking legislative update from Senator Bennett's office.
While Joy comes up, I just want to thank the panel, okay?
All right,
Joy, come over here. While all I can say is this is an incredibly fluid situation with the children. While we're sitting here, the Oklahoma Immigration Court has confirmed that all non-detained cases have been transferred out of Oklahoma now down to the Dallas court. That means that they're probably going to make the Oklahoma courts available to deal with all the cases that are going on at the Oklahoma detention facility. So this is going to be a real fluid situation as they allocate different resources. Those of you that are in the room that aren't experienced immigration lawyers, I know we have some friends and colleagues here that may not be practicing in the field but are interested in helping cases. What you should know, helping with cases, what you should know is AILA Colorado is a really welcoming organization. We have mentors and incredibly wonderful experts that will give you time and energy to help guide you through the process. If you can take on one of these cases, there'll be a lot of support for you when you do that. Joy?
Thank you. I don't know if this is news breaking, but I did speak with Senator Bennett's office just before the meeting today. Their office is very involved in this issue. They have been having telephone conferences regularly with all of the different agencies and the administration and trying to make sure that all of this coordination that's happening and all the response that's happening is going along. Of course, they're also trying to resist any efforts to chip away the protections that are in the TVPRA, so they're working very hard on that. What their office said is that there are so many right now, so many different proposals, not actual bills that have been drafted, but so much talk about different bills that are going to be coming out that that we don't know what's going to be introduced, and we don't know what that's going to look like at this point, and they're just trying to respond to everything as it comes out. However, for our purposes, what's really important is that they're going to need our help in terms of knowing if things aren't operating smoothly. Finding out some stories about some of the due process that isn't happening to help keep the TVPRA protections in place and just being able to try to respond. So I think what's really important from our standpoint is just if people are having bad experiences, if things aren't happening the way that they're supposed to be happening, we need to be communicating that so that we can get that communicated to our congressional delegation so that this information is coming up as all the political decisions are being made. So we can work on coordinating that, but we need to make sure that we have all that information coming out.
All right.
Thank
you.
Yeah, I think that's all the time we have. Thanks to the CBA for letting us use their room today. And if you haven't put your name on the sign-up list, please make sure you put your name on the list before you leave, and then we'll be getting an email out to everybody. There's one up front. And thanks everyone for coming today.